All persons having business before this court draw near, pay attention, and you will be heard. May God save the United States of America, the state of Florida, and its honorable court.
Please be seated. Welcome to an oral argument session of the 5th District Court of Appeal. As you've heard, my name is David Monaco. To my right is Judge Cohen. To my left is Judge Jacobus. We have a number of changes to the schedule today, one of which is that the Diane Harris versus Gary Williams case we moved to the 10 o'clock hour, and that the Hackett versus Grand C's case will be moved to the 9 o'clock session. Now, do I understand that Ms. C has not shown up in the first case?
The deputy said she called and she's lost.
She's lost. Okay. Well, let's do this. Let's go ahead and call, since we're moving the second case to the end, let's call the third case, GUTSHALL versus GUTSHALL first, if that's all right with you, Ms. McGuane.
Unless you'd like to just dispense with that.
Nice try. We will have a change of panel for the Harris versus Williams case. There's one other thing, and that is, please, if anybody has any cell phones or anything like that, please turn them off so that those arguing won't be disturbed by it. And finally, if the appellant wants to reserve any time for rebuttal, let me know, and I'll put it on the clock. The yellow light will go on when your rebuttal time is starting, and I'll try to give you a heads up in any event. All right, let's go with the first case. One of you two has to be the appellant. Okay.
That would be my honor, if it please the court. Good morning.
Morning.
I'm here for the appellant, who was the husband in the lower case. This is basically a dissolution issue relative to equitable distribution.
Speak up just a
I'm
moment.
sorry.
It's hard to hear.
That help?
Yeah, that's good.
It does, yeah.
This is a dissolution case, and the issue before the court today revolves around the narrow issue of equitable distribution. The parties separated their finances several times during the marriage, but in August of 2007, the wife prepared a spreadsheet and put most of the marital assets on the spreadsheet. The parties never entered into a formal written agreement, and they only partially performed some of the division of the assets.
Well, now, it's Ms. Keller, right? Yeah.
Yes, sir.
Ms. Keller, you're not contesting the assets that have already been divided up between them, are you?
Relative to that 2007 spreadsheet?
Yeah, I mean, she made the spreadsheet and they began dividing up assets at that point, right?
I'm not contesting that portion.
Nobody's contesting those.
No,
so,
sir.
It looks to me like the only major issue is about the SARs, is that right?
Well, there was accrual of vacation time, but you're right, the stock appreciation rights is the real crux of this issue.
Okay, let's talk about that then.
Yes, sir.
Did they have any value in August or in July? Actually, the petition date was what, July or June of 09? That was the petition
They
date.
had a value at that point.
I thought it was August is when they actually.
Well,
had the value.
actually, they were 50,000 shares of BDR stock. They were no longer stock appreciation rights at that point, at the date of filing. As of July 30th, 2007, they merely existed as stock appreciation rights.
So they had no value.
Well,
Well, they'd have. I mean, she couldn't do anything with them, correct?
no, she could not. They vested about a month later. However,
So they weren't vested at that time?
no, they were not. But they were not contained in the body of the spreadsheet. There was no reference to them whatsoever.
Your client took the position he didn't know about them, is that correct?
He knew there was ownership interest but he had no particular knowledge relative to the
But
SARS.
the evidence on that point was disputed.
Right. And the trial judge found that he did have knowledge, correct?
Yes, the trial judge did find that she was satisfied he had at least knowledge of the existence of ownership.
Okay.
So there is competent substantial evidence to support the trial judge's finding on that, even though the finding went against your client.
In the trial court's opinion, yes.
Well, but we're not here to, look beyond that. We don't reweigh the evidence. If the trial court makes a finding of fact, and there's competent substantial evidence to support that finding of fact, we're bound by it. Correct?
Well, the court did find that there was knowledge on the part of the husband of the existence of ownership. Yes, it did. By substantial,
Beyond
competent
that,
evidence.
the trial court found that he knew about they were SARs and what they were, correct?
I believe the trial court found that she was satisfied that he knew of the ownership interest.
Okay.
How much or what the specific definition is, I don't think she made that particular finding. But what we have a concern about is, A, that was not mentioned in the 2007 spreadsheet, that the court found that because it had, the SARS had no value as of July 30th, 2007, that, and they were unvested, that there was no need to determine or to distribute the SARS, even though there was ultimate value in the SARS, to the point that when the filing of the petition for dissolution in June of 2009, they were already 50,000 shares of stock in BDR. And there was evidence that in May, prior to the filing of the petition, the wife, because she was the comptroller of the company, it had been announced that the company stock would be sold in August of 2009.
Well, if she'd been fired in, say July 31st, 2009, she wouldn't have gotten any of those SARs, though, would she?
Well, actually, they were already converted to 50,000 shares.
They weren't vested.
At that point, there were 50,000 shares of BDR.
But not vested in her.
I believe that no, you're right.
It was August, I think.
It was August when they became.
August, you're correct.
Yeah.
At the same point, the equitable distribution statute addresses the issue of unvested benefits under 61075 and says that you have to look at, and we cited several cases, Hollister, Parry, that you have to look at and see if there was any marital labor associated with those SARs, whether they were unvested or not. And they were issued to her the year before, incident to her employment. And I'm talking 2006, to make it clear.
Mm-hmm.
So we believe that the court erred in not looking at what portion of those SARs were as an incident of marital labor from September of 2006 until July 30th or 31st or August of 2007. And they immediately, almost immediately, vested thereafter. There's also accrued vacation time that was never valued or included in the equitable distribution, and I raised that issue also.
Okay, anything else?
I think that's it.
Okay, thank you. We'll leave you 12 and a half minutes for rebuttal if you choose to use it. And we'll call the appellee now.
Thank you.
Please, the court, just in case I confuse the court, the sign over here says Judge Cohn. and the sign over here says Judge Jacobs.
What's your point?
We find it's a lot easier to, when you, to make rulings when you think we're somebody else.
That's right.
Please, the court, this case in reference to...
We could switch if it would make you more comfortable.
Oh, sir, I just thought I thought I'd lighten things up to begin
We're going
with
to talk
that.
to somebody after this is over, right?
Yeah, heads will roll.
And this clock is so screwed up. You now have 80 minutes for argument. We're going to see if we can cure that.
It's a lucky thing that you're retiring.
If it pleases the court, Judge Code, who I've appeared in front of in a trial court, knows that I'm reputed to take a long time in my...
Did I say 80? I meant 10.
But please the court, and I apologize, I have somewhat of a frog in my throat, so if I'm not loud enough, please let me know. As apparently the court has noted, this is a case where and I'm going to refer to the appellant as former husband, if that's okay with the court, but where the appellant, former husband, wants to re-argue the facts of this case as if it were before a new trial court in reference to the matters in the brief. This was a case that involved a 12-year marriage, and the circumstances here were somewhat unusual in that at the time of the period before, back in 2007, the parties had executed a whole series of events that came about and really dividing their economic partnership and basically going their own way. The former husband was to be benefiting by his new company, and the evidence showed that during the course of the relationship thereafter, that there was not, his position was, you didn't have any right to know anything about my business or anything about it. And he denied any information and denied any knowledge of the benefits from the company. Interestingly, in this case, when we made our presentation, and if the court has noted in the record, we provided a pretrial, and that pretrial statement, which we actually presented 2 different times beginning in May, we laid out 2 different approaches for the court to look at in determining how to and when to value the assets. The court chose to accept or to select the valuation dates at different times for different assets, and interestingly chose the scheme that was less in an award to us than would have been had she selected the husband's dates for valuation for all of the assets. The court found that both parties admitted that there was a plan that each would retain their own income separate from the marital estate. The court found that the items divided, as the court noted, were completed terms back in 2007, and the court found that as to most items in this case, utilizing that valuation of the items was the appropriate date of valuation to utilize.
Well, let's talk about the SARs, since they seem to be the one major issue that's still in debate. Since they were vested at a fairly substantial amount a month after the parties separated, why wouldn't they have some residual value?
Well, that wasn't the evidence. The evidence was that they did, in fact, that the evidence was that on the date of the original segregation of the economic partnership, that they had no value at all. The next piece of evidence,
Came back in 2007?
Yeah.
yes, sir. The next piece of evidence was that they vested the SARS, part of the SARS vested a month after, and I think that's what the court is talking about. And the testimony was that in December of 2007, the value was $750. And so there wasn't a substantial value to them in reference to the subsequent vesting of a piece of them, which were to occur over a period of time. I don't know if I've answered your question fully. The arguments that were made in the briefs and haven't been made here, I'm going to step over, unless there are specific questions that relate to any of those items. I think that it is clear that the pleading requirements under law is clearly generalized pleading for equitable distribution. I think we've laid that out in our brief on that.
When did she, the money, she actually got the money in August of '09, is that right?
She got it after the filing of...
After the petition date?
Yes, sir.
It might have been July of '09, I can't remember, but it was post-petition.
Yes, sir.
When she actually got the money.
Yes, sir.
Okay.
Does the court have any further questions?
Nope. Thank you, counsel.
Thank you.
All right, Ms. Keller, any rebuttal?
Thank you.
What is of concern is that the value of the SARS, well, let me go back. In the pretrial statement, for the first time, we saw a request to accept the values on the spreadsheet that was done by the wife in 2007. In essence, what was requested of the other values that were assigned as of August or July 30th, 2007, was specific performance of an oral contract. And in fact, that was never specifically requested, but in fact, that's what the court did and called the oral contract that neither party had signed.
How do you sign an oral contract?
I apologize, and I know you're never supposed to object.
No, you're not.
Right,
So
then
sit
don't
down.
do it.
Okay. How do you sign an oral contract? They say they're not worth the paper they're written on, right? I mean, that's the 3-minute law.
I see why you're sitting where you're sitting.
Well, that's good you know, because we've all wondered.
Yeah. That's a sore subject, really.
What the court did was apply an allegedly oral agreement to most of the values and
Based in part
ignored
upon
the
performance,
SARS.
based upon
Right.
the fact that it had been
Seems like
performed.
that's what they did. I mean, they had some kind of a spreadsheet that they traded money, they put money in separate accounts. I mean, it seemed like they performed whatever the agreement was up to a point. I think what his 401ks were in there because I think he may have consulted someone and decided maybe this wasn't a good idea, so they never knew the values of those. But I mean, the stuff they knew about, I mean, they split the bills, they took into account tax consequences. I mean, it seems like they actually did split their economic life back in '07. I mean, and lived by that.
And I think it's important what you just said, the stuff they knew about. It was the husband's position that he didn't realize there was value, and what the court did by saying, well, that was included in that spreadsheet, was to take an earned, given, but unvested stock appreciation right and say, well, no money was expended for it, so it had no value. And we do take exception to that under the equitable distribution statute.
Thank you.
Thank you very much.
Thank you.
Okay.
All right.
Where'd you go on one?